Good afternoon. Welcome to today's webinar, Demystifying Unfair Dismissal. The good news is we have quite a lot of people who registered for today's webinar, so we'll definitely wait a few minutes just to give them the chance to jump in. So hang tight and we'll begin shortly. All right, look, it looks like we've got a good amount of people who've jumped in so far, so I'm happy to get started. Ladies and gentlemen, a very warm welcome to you all. We appreciate your time today, and we'll do our best today to shed some light on some of the nuances around unfair dismissal. I'm sure throughout today's presentation, you'll have some questions, and we'll definitely go through them at the end of the webinar. So I highly urge you to make use of that Q&A function near the bottom of your screen, so you can actually have some of your questions answered today. So as you can see, today's title, Demystifying Unfair Dismissal. We picked today's topic as it's one that's always in high demand on our advisory line, especially as it can sometimes feel like termination or doing a redundancy can be a bit of a minefield. And it is difficult to know what best practice steps you are meant to follow. So on one hand of the spectrum, I also feel that I speak to businesses that feel that moving on employees from a business is a simple and easy task. They just tend to not be as informed as the specific steps they need to take to avoid facing a claim. So hopefully today we can address any questions or doubts you had around unfair dismissal and can help you make sure that you're as informed as possible after today's session. So before we get started, I'd like to introduce you to today's speakers. So at the top, you'll see that we're lucky enough to have Brigitte present today's information and answer your questions. Brigitte is one of our very knowledgeable workplace relations consultants, and she's a core member of our advisory service. So today she'll be walking you through today's topic and guide us through understanding unfair dismissal. Just below her, you'll find me. My name's Anu. I'm a business development coordinator for HR Assured. There's another introduction I'd like to make. For those of you who aren't familiar with our family, on your screen, there are the current members of our FCB family. There might even be some names you haven't seen up there before. So starting from the top left, we have FCB Workplace Law, which is one of the leading employment relations specialist firms in Australia. And FCB Workplace Law has been in the industry for 30 years now, and it's pretty much the backbone of where we get our expertise in employment law. Next, we see FCB Smart Visa, which is our immigration and migration practice. We jump to the bottom left, we have Enable HR, which is our proprietary technology solution. It exists to help you manage your HR and health and safety in like a cloud-based system. So just helps making managing workers less complicated and easier to do. Enable HR is quite unique. It's actually been built and maintained by FCB Workplace Law. So it's really excellent helping businesses maintaining compliance and following best practice. After that, you'll see QMS and Best Practice, our certification services. They are the newer members of our family, and they'll be able to help out if you're looking at ISO certification for your business, as well as NDI certification under QMS. But the banner in which I will be speaking to you today is HR Assured. So HR Assured is your external HR and health and safety partner for you and your business. Its slogan has always been avoid admin, create the culture. That's one of the ways in which we best support businesses. So most of you who are here today probably have some sort of responsibility around the HR or health and safety side of the business. So we understand a lot of you guys don't really want to spend so much time ensuring that you're meeting all the legislative requirements of managing employees and doing all the admin that comes along with that as well. So HR Assured essentially exists so we can take as much of that work off your hands so you can spend more time on things that are more impactful to the business, such as working on your business strategy or your workplace culture. So how we do this, when a client comes on board, the first thing we do is a comprehensive HR audit. This is to help diagnose what parts of the organization need assistance. So what we'll do here is identify those critical areas of non-compliance, which we'll jump on straight away. And then we'll work with you to plug in all the holes and ensure that the business is following best practice. You'll then have unlimited access to our advisors 24/7. So you'll always have a professional essentially at your fingertips. So whenever you find yourself in a tricky situation, you'll have someone to turn to actually help you navigate through that. We'll also give you access to cloud-based software to help you manage things and help it a lot less complicated to follow best practice. And then you'll have access to a library of legal resources from our law firm, which constantly keeps those updated as well. Quite importantly, you'll have access to our advice promise, which is a protection mechanism for our clients in the event you ever face a employment-related claim from an employee. As everyone should be aware, sometimes, no matter how many steps you take or following best practice and you've managed everything well, you might still face a claim from an employee. So what we have to do there is actually defend that. And that can end up being quite costly and frustrating. So our advice promise essentially means that for our clients, whenever you do receive one of these claims, we'll actually stand beside you, represent you in court if needed, as well as paying out other costs associated with the claim for you. And all of that actually comes included in a low monthly cost. So do reach out to me if that's something you'd like to look into, and we can definitely explore that option with you. With that in mind, I'd like to hand over to Brigitte to take us through today's agenda. Over to you, Brigitte.
Thanks, Anu. So today we're going to look at the following topics. So firstly, what is an unfair dismissal? What does being dismissed actually mean? Who can claim it? Are there any objections to it? And then we'll have a look at the criteria for considering harshness, serious misconduct, remedies, a few case studies, and then we'll go through any questions at the end. So as indicated by the title, we are solely going to focus on unfair dismissal today. Otherwise, we might keep you here all day going through all of the different Fair Work Act remedies. But as a general overview, when we're looking at risks associated with termination of employment, we have unfair dismissal, unlawful termination, adverse action, and other general protections claims like discrimination as well. So what is unfair dismissal? Unfair dismissal is when an employee is dismissed from their job in a harsh, unjust, or unreasonable manner. If successful, unfair dismissal claims can be extremely costly for employers, with the maximum payment of compensation being 6 months of wages. However, it's important to consider that if a dismissal is found to be unfair, the Fair Work Commission has to consider reinstatement of the employee to their previous position before considering an order for compensation. It's especially important to consider harshness when terminating an employee for serious misconduct, as this is a factor that the Commission do take into consideration, and they'll also consider both the personal and economic consequences of the dismissal, as well as whether it was proportionate to the gravity of the conduct. So naturally, an important question to ask then is, what does being dismissed actually mean? So we go to the Fair Work Act itself to get our definition. The term dismissed is defined in the Fair Work Act as a situation where a person's employment has been terminated at the employer's initiative, or a person was forced to resign because of the conduct or course of conduct engaged in by the employer. It's important to also note that a dismissal does not include where a person is demoted in their employment without a significant reduction in duties or remuneration and remains employed by the employer. Does not include where a person was employed under a contract for a specified period of time, specified task, or for the duration of a specified season, and the employment comes to an end at the end of that period. Doesn't include if a person had a training arrangement with their employer, which specified that that employment was limited to the duration of the training arrangement and whose employment ends at the end of that training arrangement. So who can claim unfair dismissal? Award and enterprise agreement covered employees are eligible. Non-award and enterprise agreement employees are also eligible as long as they're below the high income threshold, which is currently 162,000. Casual employees can also claim unfair dismissal as long as they are regular and systematic and have a reasonable expectation that their employment would continue. And fixed term or fixed task, seasonal employees, apprentices, and trainees cannot claim unfair dismissal unless their employment has been terminated early. So that's the kind of exceptions we were mentioning earlier. So the Fair Work Commission can only deal with unfair dismissal applications that fall within its powers, known as its jurisdiction. If an employer believes that the Commission doesn't have the jurisdiction to deal with the unfair dismissal application, or that the person isn't actually eligible to make the application, then the employer can raise a jurisdictional objection. So these include that the employee is within their minimum employment period. So that's 6 months for large employers and 12 months for small businesses, which is employers with less than 15 employees. Another objection is if the application is out of time, so it was lodged more than 21 days after the dismissal. But just note the Commission can choose to make an exception to this and still accept the application anyway. It's an objection if the individual was not an employee. So if they're a contractor or a labour hire employee and they're claiming against a host. It's an objection if the individual was not dismissed. So if they resigned or they're a casual and they just didn't have any vacant shifts available. Another objection is a case of genuine redundancy. Or if somebody earned more than the high income threshold and they're not covered by modern award or enterprise agreement. So as I mentioned, that high income threshold is currently 162,000. And if they're also award free and enterprise agreement free, then they're not eligible to make an unfair dismissal claim. So let's circle back to the concept of harsh, unjust, and unreasonable. In practicality, these will often overlap. But harshness looks to whether the personal consequences on the employee were excessive or if the termination was disproportionate. Unjust looks to whether the employee was not guilty of the misconduct. And unreasonable looks to whether the evidence supported the employer's conclusion. But as I said, in practice, these can often overlap. A dismissal could be unjust because the employee wasn't guilty of the conduct, could also be unreasonable because the evidence or material before the employer didn't support the conclusion, and it could also be harsh because on the employee because of their economic or personal consequences resulting from being dismissed, or harsh because the outcome is disproportionate to the gravity of misconduct. So it's a principle essentially if the punishment didn't fit the crime. After determining that an employee is protected from unfair dismissal and that the employee has been dismissed, the Fair Work Commission is then required to determine whether the dismissal was unfair within the meaning of the Fair Work Act. So in considering whether it's satisfied that a dismissal was harsh, unjust, or unreasonable, the Fair Work Commission must take into account the criteria in Section 387. This includes whether there was a valid reason for the dismissal related to the person's capacity or conduct, whether the person was notified of that reason, whether the person was given an opportunity to respond to any reason, any unreasonable refusal by the employer to allow the employee to have a support person present, if it relates to performance, whether the person had been warned about that unsatisfactory performance prior to the dismissal, the degree to which the size of the employer's enterprise would be likely to impact on the procedures followed in effecting the dismissal, the degree to which the absence of dedicated HR management specialists or expertise would be likely to impact on the procedures followed, and any other matters that the Fair Work Commission considers relevant. So the phrase must take into account means that each of the above criteria are mandatory and must be considered in determining whether a dismissal is harsh, unjust, or unreasonable. So the criteria need only be taken into account to the extent that they're relevant. So for example, subsection E about performance isn't going to be relevant for a dismissal that's related to serious misconduct or a dismissal due to incapacity. An employee is entitled to both substantive and procedural fairness in respect of a dismissal. So substantive fairness will be satisfied if the grounds on which the dismissal occurs are fair grounds, and generally speaking, a dismissal will be procedurally unfair if the manner or process of dismissal and the investigation leading up to the decision to dismiss is just. So what is a valid reason? As we've just seen, the Fair Work Commission must take into account whether there was a valid reason for the dismissal related to the person's capacity or conduct, including its effect on the safety and welfare of other employees. So a person's conduct is fairly self-explanatory as a reason for dismissal, but an employee's capacity that refers to their ability to do the job as required by the employer or their ability to do the work they're employed to do. So the concept of capacity as a basis for a valid reason for dismissal goes beyond the physical capacity or skill of the employee and also encompasses situations where employees don't have or don't maintain the necessary licenses, certifications, qualifications, approvals, or accreditations to lawfully perform the inherent requirements of their job. Where an employee cannot perform the inherent requirements of their job and there is no reasonable scope for the employee to be redeployed into another role, it's possible that there will be a valid reason for dismissal based on the employee's capacity. So these are mandatory criteria to be considered. The reason must be sound, defensible, or well-founded, and it won't be enough for the employer to say that it believed the termination was for a valid reason. Well, what about when you're terminating someone for serious misconduct? Well, serious misconduct is a whole other webinar in itself, but let's take a quick look at what the Fair Work regulations define it to mean so that we have a better understanding of what we can terminate for on the grounds of serious misconduct. Serious misconduct is willful or deliberate behaviour by an employee that's inconsistent with the continuation of their contract of employment. Conduct that causes serious and imminent risk to either the health and safety of a person or the reputation, viability, or profitability of the employer's business. It includes the employee in the course of employment engaging in theft, fraud, assault, sexual harassment, being intoxicated at work, and refusing to carry out a lawful and reasonable instruction that's consistent with their contract of employment. It would be harsh, unjust, and unreasonable for an employer to dismiss an employee summarily on the grounds of serious misconduct without taking reasonable steps to investigate the allegations of misconduct and give the employee a fair chance of answering them. Where there are allegations of serious misconduct, the employer will want to be able to evidence that they conducted a full and extensive investigation into all of the relevant matters as was reasonable in the circumstances, that they gave the employee every reasonable opportunity to respond to the allegations, and that the employer honestly and genuinely believed and had reasonable grounds for believing on the information available at the time that the employee was guilty of the misconduct alleged, and that taking into account any mitigating circumstances either associated with the misconduct or the employee's work record, that such misconduct justified dismissal.
All right. I know we covered a lot of quality content already, and I can see we've had quite a few questions come through already, which is really great. We'll cover as much of these questions as possible at the end of the webinar, but in case we don't cover all your questions or you have something more sensitive you want to discuss more specifically, if you pull out your phone and scan this QR code, this will give you a chance to conduct a complimentary workplace compliance consultation with one of our colleagues. In this consultation, we can discuss the topics related not only to this webinar, but about you and your business. So if you haven't done like an external audit or HR assessment for a while, this is perfect for you. This will help you actually have someone look at your current setup, with your employment contracts, your policies, your HR management systems, as well as any potential employee issues you may have dealt with in the past or present. And yeah, hopefully you can walk away from this better informed about how you can move forward. As you know, it's the duty of the business to ensure that it's fully aligned with the regulators, and it's our duty to help you achieve that. So, and unfortunately, it can be a difficult task to do that in an already difficult environment. So, yeah, there's no obligation to this workplace compliance consultation. So hopefully it's a win-win situation. If you can't scan it, there will be a link in the Q&A, so you can click that. But I'll give you a minute to grab your phone out and scan the QR code so you can make use of that. Right, hopefully that was long enough. We'll also send you an email after the webinar. So yeah, definitely check out any emails in your inbox. And yeah, you'll still have access to that workplace compliance consultation. But yeah, back over to you, Brigitte.
Thanks, New. So now we're going to take a look at a couple of case studies around the topic of a valid reason for dismissal. So in this first one, here we had an executive administration assistant whose role included being responsible for payroll. So the employer alleged that the employee had manipulated the payroll system to take over 450 hours of time in lieu that hadn't been authorised, including converting annual leave to time off in lieu or toil. The evidence was that the employee had worked additional hours in the kitchen and that those additional hours and time in lieu hadn't been recorded adequately by the employer. The employee's evidence was that she was responsible of keeping count of what she was owed, and she did that by putting toil into the payroll system. What happened is that the employer summarily dismissed the employer summarily dismissed the employee, so summarily being without notice on the basis of fraud. So what did the Fair Work Commission say? Well, they considered if the employee's conduct could actually be categorised as fraud. They said that the basis of the dismissal was said to be fraud, but on the evidence before them, this may be overstating the circumstances. The employee sought to explain each of the events relied upon by the employer, but it appears that its ignorance of its industrial regulations conditioned its approach to the termination of employment. So they considered the extent to which the employer's poor practices and systems had led to the employee doing what she did. They identified whether the additional hours equaled the time in lieu claimed by the employee, and ultimately they found the dismissal to be unfair, and 4 weeks' pay was ordered as compensation in lieu of reinstatement. We'll jump into the next case. In this one, we have an employee who was a lifestyle assistant. She'd been working with the employer for 2 years. So the alleged conduct was that the employee had repeatedly shouted at another employee in front of residents, staff, and clients, following 2 prior allegations of verbally abusive language. The evidence was that 2 months earlier, the employee had received a first and final written warning about the 2 prior incidents. And the evidence also showed that the employee was a good performer and was dedicated and caring towards residents. There had been multiple witnesses to all the incidents concerned as well. So Fair Work Commission in this case considered the consistency of the witness evidence and the reason as to why the employee was raising her voice, which was due to frustration as to working practices and resident issues and the perception that she wasn't being listened to by her employer. They also assessed the reasonableness of her actions and considered the context of the incident, being that they were in a residential care facility surrounded by residents and standards of communication. Ultimately, they found that there was no valid reason for the termination, as the conduct was provoked by the inappropriate or unfair actions of others, and that termination as a response was disproportionate to the conduct. So let's go back to the factors that the Fair Work Commission has to take into consideration and look at the ones related to procedural fairness. So these are the ones about whether the person was notified of the reason for dismissal, whether they were given an opportunity to respond, any unreasonable refusal to have a support person, and then if it relates to performance, whether they'd been warned about that performance before dismissal. So this stage involves essentially the collection and assessment of relevant facts relating to the alleged conduct of poor performance. As part of this process, employers must allow an employee an opportunity to respond in the investigation process or the assessment of their performance. In an ideal world, this should form part of a broader and ongoing cycle of performance conduct management. But just to keep in mind, this stage of the process often involves attempts by the employee to obstruct that process. So they might raise allegations about others, they might refuse or fail to attend the investigation interview, but in the absence of a lawful and reasonable excuse of refusing or failing to attend, that in itself may constitute a failure to follow a lawful and reasonable termination. We're going to have a look at a case study about procedural fairness now. And when doing any termination, especially where one where there is a risk of unfair dismissal, it's really crucial for the process leading up to the termination to be undertaken in a fair way. So just as a side note with this one, while this case was decided prior to the Fair Work Act's existence, because it's a 2003 case, the same criteria for harsh, unjust, or unreasonable and the same principles applied in the previous IR Act before the Fair Work Act. So here we had an employee working for 20 years as a night shift supervisor on permanent night shifts. He was terminated after 25 years of employment for sleeping at work. Prior to his termination, he had been told verbally not to exceed his break time when sleeping on his break at work, and that as a senior employee, it was highly inappropriate for him to be sleeping on the job, and it would be investigated further. He was then brought into a meeting on the 17th of July 2002, and the allegations of sleeping at work were put to him, and he was provided with an opportunity to respond to them, but he chose not to. The employee was not told that if he was found sleeping on the job again, that they might consider terminating his employment. What happened then is that management actually made a decision after that meeting to terminate the employee. And after they'd made the decision to terminate, they then brought the employee into a meeting on the 29th of July 2002. So the Commission was satisfied that there was a valid reason for the termination, and this was primarily due to the fact that the employee continued to sleep at work despite the employee actually undertaking to management that he wouldn't do so. But they had another issue with this termination, and that was that the decision to terminate the employee, as I kind of alluded to before, was made by management prior to the meeting on the 29th of July in which he was terminated, to which the Commission said that it follows that the employee wasn't notified of the reason for the termination of his employment prior to the decision to terminate. So because the employee wasn't notified of the valid reason before the decision to terminate, he therefore wasn't really provided with a proper opportunity to respond to the reason for termination before the decision had been made, because it was made before that conversation had even happened. So the remedy in this case, they found the dismissal was unfair, and the remedy was over $9,000 in compensation because they felt that reinstatement was inappropriate due to the circumstances. So now that we know a bit about a claim, let's look at the remedies. If the Commission is satisfied that the person was protected from unfair dismissal at the time of being dismissed, and they found that the person has been unfairly dismissed, then they may order a person's reinstatement or the payment of compensation to a person. The question of whether to order a remedy in a case where a dismissal has been found to be unfair is discretionary. So with reinstatement, the Commission has to determine if that's appropriate first before considering anything else. It's not until the Commission is satisfied that reinstatement is inappropriate that they can consider compensation. So reinstatement means that they must reappoint the person to the position in which they're employed immediately before the dismissal, or appoint the person to another position with terms and conditions no less favourable than those on which the person was employed immediately before the dismissal. With compensation, it's really designed to compensate an unfairly dismissed employee in lieu of reinstatement for losses reasonably attributable to the unfair dismissal. So compensation can't be awarded for, shock, distress, or humiliation caused to a dismissed employee by the manner of the person's dismissal. And Section 392 of the Fair Work Act sets out the criteria for determining the amount of compensation that may be ordered. The Commission is to take all circumstances into account, including the effect of the order on the viability of the employer's enterprise, the length of the person's service with the employer, the remuneration that the person would have received or would have been likely to receive if they had not been dismissed, the efforts of the person, if any, to mitigate the loss suffered because of dismissal, and the amount of any remuneration earned by the person from employment or other work during the period between the dismissal and the making of the order for compensation. So they'll take all those things into consideration before either making an order for compensation or making an order and deciding on how much. So just a few key takeaways from the content and case studies that we've looked at today. A valid reason to terminate does not completely mitigate the risk of a successful unfair dismissal claim. And I think this is where a lot of employers will kind of miss this point, is because, you know, if you feel like your dismissal is justified, you feel like you should be able to dismiss that person. And while that may sometimes be true, as we've kind of gone through with the procedural fairness case, even if you have a valid reason, that doesn't mean you can't have a claim brought against you and have that claim actually be successful. So whether an employee has been given a proper opportunity to respond to the reason for their termination, that can be a really vital point in the success or failure of an unfair dismissal claim. When issuing a warning, make sure you communicate to the employee, evidenced in writing, that their continued underperformance and/or conduct may result in further disciplinary action up to and including termination. Make sure that you give employees a chance to respond to the reasons why you're considering termination before that decision to terminate is made. And don't prepare a termination letter before a meeting, which is seeking the employee's response to the concerns, because that can indicate a predetermined outcome. So it kind of follows on from that point before. I would encourage you to keep an open mind before and during a termination meeting, and genuinely consider the response of the employee prior to making a decision. And keep documentation of all performance and disciplinary discussions and outcomes in all cases. Then I'll just end with some practical do's and don'ts. So do make sure you consider the decision-making structure in the situation. So isolate the decision maker and ensure where possible that they don't have a special interest in the outcome. For example, if there are allegations made against them. So if you've got an investigation against a particular employee, they then make allegations against the person that's doing the investigation, it's really important that that person is kind of swapped out and isolated so that there's no kind of conflicts going on. Make sure that the decision maker knows why they're terminating, and make sure that you keep a good paper trail, so written records of everything. Be consistent with your communication and process, and don't rush the process. It's better to get it right the first time, but don't shy away from revisiting decisions if you find out at a later stage that they have been affected by error. And don't forget to provide employees with the opportunity to respond to all concerns. So not just some, but all.
Thanks, Brigitte. That was really informative. So I'm jumping in again to remind you of the QR code in case you weren't able to do it earlier. Or maybe you heard a few things just now from Brigitte and maybe made me feel like, hey, maybe I do need a third party to help me see where I stand right now. It feels more complicated than I thought. So just to recap, the complementary workplace compliance consultation will help uncover any key risks or threats that the business might be exposed to. And it's to help you understand what you need to do to be more compliant with the current laws in Australia. So we can confidently say that the consultation is a very good opportunity to identify those risk areas in the business, especially the ones you may not be aware about, so you can have some direction on how to move forward from here. I mean, for example, a really hot topic at the moment that I'm hearing a lot about in my role is a lot of people are looking to get some clarity on the secure jobs and better pay bill that came out recently. So the consultation is a great chance to reach out to get some clarity around that, or the webinar topic as well, just to help ensure that you are compliant all round. So I'll just give you another minute to scan the QR code. All right. Before we move on to the questions, I thought I'd remind you of the support HR Assured provides. As I mentioned earlier, we can be that external workplace relations partner for you in the business. So that's really to help you make sure that you're in control of your HR and health and safety obligations. We hope that when it comes to staying compliant, that your philosophy is to be more proactive rather than reactive. And if that's the case, then we can really help you achieve that. But yeah, we'll jump to the questions. Now, we'll go through as many of these as we can, but I've seen a fair few come through, so we'll try and be conscious of time. But if we can't get through your question today, I definitely recommend using that QR code to try our advisory service for free. Hopefully, it will give you some insights as to what having a workplace relations partner for your business would actually look like. But yeah, we'll just look into the questions now. So first question, we are a small business and recently we had to let go of an employee for serious misconduct. They have not made an unfair dismissal claim, which is worrying as I've never had this happen to me. How can HR Assured help?
So I'm going to assume that they've now made an unfair dismissal claim, in which case, as far as how HR Assured can help, I would say that before you get to this stage in the process, it's better to get HR Assured on your side. Because if you can call us before your terminations, what we'll do essentially is assess and scope out the risk. We have an internal termination approval process, and we have the advice promise as indicated before. So moving forward, we'd be able to help you prevent it from happening again. But if you're coming to us with a claim, then we can provide representation through FCB workplace law, which is another part of our FCB family.
Sounds good. Next question. We have an employee who has not been performing for a while. I have given them multiple chances to improve. I feel that my only option is to terminate their employment. Can I?
It's always a loaded question, can I terminate someone? Because the reality is you always have the option to terminate someone's employment. However, when you do it, how you do it, and the circumstances around it is going to affect the level of risk in a termination. It's not as simple as a yes or no. So we'd need to dig deeper into the employee's length of service, performance management undertaken, the actual nature of the performance issues, if they've been offered extra training, if they've been given warnings, any possible discrimination or health factors that might be affecting the performance, and other issues like that before we kind of came to an answer on whether we would suggest terminating or not.
Thanks, Brigitte. All right, we'll see if we can do one more, just conscious of time. If an employee makes an unfair dismissal claim, what is the process? Does it go to court? Do I need legal support?
Well, the process for an unfair dismissal claim is basically like this. So after someone makes a dismissal, after you make the dismissal, that employee has 21 days to make an application to the Fair Work Commission. Otherwise, there's that jurisdictional objection that we talked about earlier. Then what will happen is the Commission will organise a telephone conciliation with you and the employee, and the employee's representative if they have one, and your representative if they have one. Everyone gets on a group phone call essentially. And then you have the conciliation, so the back and forth with the conciliator and try and settle the matter. If it can't be settled through that first conciliation, then it goes to an arbitration hearing with the Fair Work Commission, and then they'll make a decision. It's not a requirement for you to have legal support, but we recommend having representation to make sure that you can get the best outcome for your business.
Perfect. I think we can fit in one more. So we are a medium-sized business and need to make a few employees redundant due to financial factors. Are we opening our business up to unfair dismissal?
Well, as the answer often is, that kind of really depends. So with redundancy, redundancy is an objection to unfair dismissal if it's genuine. So with that question, we'd need to look at, is the redundancy a genuine redundancy? And then if it is, then you've got an objection to unfair dismissal. If it's not, then there might be some issues there. If, employees are outside their minimum employment period, their award covered, all of that. If they're eligible, then it may potentially be a risk, but it would really depend on that redundancy.
Perfect. I think we can fit in one more. It's a pretty common one that I've seen a few times, but what is the process if you do face an unfair dismissal claim?
So I think that's what we just went through before. So we've got the 21 days for them to make the application. Then you'll essentially get informed. I believe you get a letter or an email from the Fair Work Commission about the telephone conciliation. That all gets organised. That happens. Hopefully it ends there. That's the end. If it doesn't get settled or agreed with you guys in conciliation, then it will go to a hearing, arbitration hearing.
Perfect, perfect. All right, well, I think that's it from us today, just being conscious of time there. So thank you so much, all of you, for spending time with us again to watch this webinar. We hope you took advantage of the initiatives that we were offering today, but more importantly, we hope you walked away with some information that's valuable to you. So we do these webinars quite regularly, so definitely look out for the next one, and we will be in contact with you soon. So take care, stay safe, and I hope you all enjoy the rest of your day. Thanks.